Immigration attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments. Now, I am going to talk about a particular topic that I'm pretty sure will interest you today. But keep in mind that as soon as I'm finished talking about my topic, I'll turn to your questions so you can put your questions in the comments as well. So here I have a statement, and it's my spouse canceled my green card. What can I do? Right? There are ways to take action to protect yourself in the case that a spouse has compromised or they are threatening to compromise your permanent residence. It has been recognized by the USCIS that if your spouse is constantly using your immigration status, the green card process, as a way to control you, that does qualify you for VAWA, which means that you can apply for your own permanent residence, your own work permit. If you already have a work permit and you're now waiting for the green card through marriage, you can change it to your own process and continue to renew your work permit until you get approved for residence. So I want you to know that it is possible to even fix a situation where the spouse has gone ahead and even canceled your green card application. Now, can a spouse actually cancel your green card? No, they cannot. And you can. So if you say, for example, you have your 2-year green card and you're going to the 10-year, but your spouse is constantly saying they're not going to give you the green card, they're going to cancel it so you don't get the 10-year, just know that you can apply for your own green card. You don't have to solely depend on them to keep you in status as a permanent resident. But in the case that you haven't achieved permanent residence and they've canceled your green card application. So sometimes I've seen this happen with my clients. I do have clients where the spouse went behind their, wrote a letter to immigration and canceled the permanent residence application, right? The petition, because the spouse has to file a petition. So the spouse, in the case that the spouse is applying on your behalf, they're very much in control of your permanent residence process. So and it is up to them to go ahead and write to immigration to say they no longer want to petition for you. It is a choice that they make. However, the way that you can take control of this process is where their motivations for doing this is wrong, right? If they're using your immigration status against you, if they are retaliating against you, for not doing what they want, or they're just being plain cruel to you, and so they go ahead and cancel the petition behind your back, or even if they do it in front of you, just know at that point you can use what they did to you wrongfully to up your own permanent residence. And this is because no spouse no spouse who has your best interest in mind, no loving spouse, no spouse who is respectful of you is going to do something like this. They're not going to want you to stay here in the United States without your work permit or your permanent residence, without status. They're not going to want to leave you hanging. And so if a spouse is constantly threatening, or they've threatened a couple times, or they've threatened 1 or 2 times that they're going to do this to you, just know that that's wrong. It's a form of abuse, and you can apply for your own process based on this. Now, say you're going through the process right now, and now that you know what can happen, what has happened to my past clients, I want you to think about now, how can you protect yourself? And in the case that you do want to take action to protect yourself, I do help my clients to do this. And the first thing I do as the attorney is I contact the USCIS to have the petition switched from the spouse we file a new petition under VAWA, and the work permit, the adjustment of status application, the travel document are all switched over to the new VAWA process. We call it VAWA. And then the process continues and you're still able to continue. So if you already have your work permit, if you already have your social security and your travel document, you can continue to have those with your new process. If you haven't received those yet, or you haven't even applied for it yet, just know that applying from scratch is possible to be able to get your own. You don't need to have a process going to get your work permit. You can do it from scratch as well. This is exactly what I help my clients with. You don't necessarily, let me worry about all the different processes to get you to the place where you need to be. What I need you to understand is it's possible. You can protect yourself and you can get this done. Go ahead, get in touch with me, and we can first confirm you qualify and then get started. But a spouse cannot cancel your green card. In the case that your spouse needs to jointly apply with you to get the 10-year, there are ways to get around that. So if your spouse is now saying that they can have the control to take away your 2-year green card, then just know that that's not the case. You do have ways to apply based on divorce, based on extreme cruelty or abuse, and also based on extreme hardship. So if you're going from the 2-year to the 10-year, they can't take away your green card so easily. You should not make it that easy to lose your green card, because that this spouse is threatening to you. If you don't have your green card yet and they're threatening to cancel your green card application, you can also protect yourself in the case that they are threatening. Say they're using your immigration status against you. The sole reason that they are trying to withdraw the petition is in retaliation against you. If they're trying to teach you a lesson, if they are trying to prove a point, if they're trying to get you to comply with them, or if they just want to keep control of you to make sure you don't get status, then this is a basis for VAWA. Now, the other thing I hear is I don't have any evidence that the reason that they're threatening to cancel, or that the reason they cancel was because they're trying to control me. You have your memory of this, and your memory of this is enough to be able to bring this before the USCIS to ask for relief. So what I do with my clients is, you'd be surprised. You think you don't have evidence until I work on these time and time and time again. I brainstorm with my clients and we make sure that we find the creative solutions to be able to prove this to the USCIS. Now, the kinds of evidence that the USCIS requires is any credible evidence. That means any believable evidence. That means that, for example, if your declaration, your statement can be considered evidence if it is credible. And I make sure that we include all the elements in the declaration to shore up your application, and for them to accept it as evidence. And then there are other types of evidence that we do include, just depending on what the relationship was like. For example, we've used text messages, we've used WhatsApp messages, we've used voice notes, we have used witness statements. So the types of evidence that we use is going to be varied depending on what happened, the circumstances involved, and how things went down. So that's where it's important for you to get the help so that you do it right. And that's exactly what I do. I help my clients to do it right. All right, so I'm going to go ahead and go through questions. So go ahead and put your questions in the comments. Okay, so can a green card holder file for a child, and how long does the process take? Yes, green card holders can sponsor their unmarried son or daughter who's under 21 Right now, that's on the same timeline as a U.S. citizen sponsoring their child who's under 21 and unmarried. You're looking at about 2 years if the child is outside of the U.S. You're looking at possible 6 months to a year if they're in the United States. And if they qualify for adjustment of status, if they're out of status, then it's going to be a more complex process, and you want to make sure you understand exactly what the eligibility requirements are. If they're here with status, you also have to make sure that they qualify to adjust status by having their current priority date, which right now it's current, and that doesn't last. So you should definitely get in touch. We'll talk, and then we'll get that done for you ASAP. Hi there, Sharelle. Nice to see you. All right. So, my wife, who is not my daughter's mother, submitted an I-130 application for myself and my daughter, who's 17. I'm in the US, but my daughter's in Jamaica. Can her mother, who recently got married, also submit a petition for her too? So that is very specific, right? Two processes can be going on at the same time, and it all depends on which one goes through faster. But is that a good idea? It's going to depend on what facts are involved. If your daughter qualifies as a stepdaughter under immigration law, so you got married before the child turned 18, which obviously you did, and that means that the U.S. citizen stepmother qualifies to sponsor the stepdaughter, and the timeline right now is similar to that of a permanent resident biological parent sponsoring their child. So, can her mother, who recently got married, also submit a petition for her to, not the mother, but the other step parent, right? So, whether it's a good idea for both step parents to be applying for one person, that it may be six and a half dozen. You want to make sure you get legal advice. So this is very specific, and the situation is a little cumbersome. It's six and a half dozen really to have two step parents applying for one child. So it's kind of like, pick one. Another thing you should note is that there can't be one I-130 for both you and your daughter. In the case where a U.S. citizen step parent is sponsoring the stepchild, there has to be two I-130s filed. Can someone sponsoring an individual, can a prenup be done? So I think I answered something like this before. Prenups you should ask an attorney, a family law attorney, or an attorney that specializes in prenuptial agreements. Whenever someone is sponsoring another person, they have to sign what's called an affidavit of support, and the affidavit of support can conflict with the prenuptial agreement, because remember, the affidavit of support is a contract with the government saying that the sponsor is going to be financially responsible for the immigrant for the next 10 years or until the immigrant becomes a citizen, while the prenuptial agreement is limiting the amount of financial responsibility that one or both parties have for each other. So they can conflict. So you have to make sure you bring this to the attention of the attorney who is doing the prenuptial agreement, so they can draft it in a way that does not conflict, or they can advise how to get around this conflicting information. A USA citizen is getting married to a spouse already in the USA. Can they do a prenup? Go to an attorney who can do the prenuptial agreement and advise on that. So after all documents are submitted, how long to get an interview and medical? So it's, of course, it's going to be estimated. It's ranging anywhere from, so I've seen 5 months to a little over a year. It just depends, though, on how did you present your application. That is what counts here. The quality of your application, that's going to say how long your process is going to be. How does one qualify for adjustment of status if your spouse petitioned? So you have to be one, you have to be in the United States, and the other, you have to make sure you either, if you're the spouse of a permanent resident, that you have a current priority date and current immigration status. If you don't have the current immigration status, you want to make sure that that you qualify despite, because usually you won't unless you're the spouse of a U.S. citizen. What is the average wait time on a marriage-based interview? It varies. It just depends. I've seen anywhere from 5 months to a little over a year. But once again, it comes down to the quality of your application. Hi there. It's always a pleasure as well. Someone overstayed on their visa over 15 years. They are currently in a relationship and want to get married but don't want to be deported. What can they do? So it's going to depend. I mean, people who are here without status get married and they end up going through a successful immigration process. But it's going to depend on what's the status of the spouse. Can the spouse who a U.S. citizen spouse can assist their spouse to be able to get status here, and they won't necessarily be deported. But if there is a history of deportation, that can be the situation. So in a case like this, make sure that you are getting legal advice to know how to move forward. All right. So I don't see any more questions. So I'm going to day. Thanks so much. Okay, so I see it here. Also, can a consultation be done with a family member present? So if that family member is involved in the process, they can be present. But keep in mind that the consultation is confidential. But when you have third parties coming into the consultation, it does compromise the confidentiality, meaning that if this third party decides that they want to go and disclose all that was discussed in the consultation, then it's fair game. And so I'm very protective of the consultations and who comes into the consultations, because I want to make sure that I'm also protecting confidentiality. Because whenever, I do have the professional responsibility to maintain confidentiality, and confidentiality can be broken under certain situations. And so if that third party throws an element of risk there in regards to individuals' confidentiality in a consultation. So my policy here is, if the individual is in some way related or relevant to the service that I have to provide to the client, if they're going to also be a client, or they play some determining role, if they're a petitioner, for example, then sure. However, in the case where they're just there to listen in, I do disclose to the individuals that they are compromising the confidentiality of the consultation, not on my side, but on the side of the person who is sitting in and listening. How long after file all your documents can one get a work permit? So I've seen it depends on the process, but if you're going through adjustment of status, I've seen anywhere from 3 weeks to over a year. For example, VAWA is 6 months to a year, But adjustment of status is anywhere from 3 weeks to 6 months. 3 weeks is on the freakishly fast side that I've seen. But I would say expect anywhere from 3 to 6 months for any other type of adjustment of status. Hi there, Bob Brisky. Nice to see you. How soon after coming up can you start filing if already married to a citizen? So, timing is going to come down to the couple. There's no rule that says you can't file right away, but is it a good idea, right? Because there can be some legal implications and so even some harsh consequences in regards to applying right after arriving here in the US. So you want to make sure that you protect your interests by getting representation and during representation, advice as to how to approach this. Because there's no rule, but you might end up in a self-imposed trap yourself by filing too quickly after arriving into the US. So make sure you protect yourself and get the legal advice you need. Okay, so the person is not savvy with the process. So if they're not savvy with the process, this is where they should get representation. It absolutely makes a difference because if they're not savvy, it means that they will very well get themselves into trouble and it turns into a painfully long process. When filed VAWA, do the travel documents come same time as work permit? In some cases, right now they're trying to rush work permits because most people want the work permits, they want to get to work, they want their social security number. And so to speed up the process, they have been issuing the work permits separate from the social security numbers. But traditionally, the work permits have been coming with the travel document on the same card as the work. All right. So thanks again, everyone, for joining me. I will be back tomorrow where I will come with a topic. You come with your questions and we can talk about it. I'm here Mondays through Fridays around lunchtime to talk about the different topics and also to take your questions. So I will be back tomorrow. Thanks so much, everyone. Have a good one. Bye-bye.